Thank you.
Hanover Insurance Company versus Rapo Insurance
Thank you. Mr. Cannon, good morning.
Good morning. May it please the Court. My name is John Kiernan. I represent Rapo and Jepson Insurance Services, Incorporated. And with me today, and the author of the brief, is Valerie Plecker. At the outset, I note that I'm sharing the time with our Bella's counsel, Roberta Fitzpatrick, and I shall be brief and to the point. At the outset, I would like to thank the Friends of the Court, the New England Legal Foundation, the Boston Bar Association, and the Associated Industries of Massachusetts, whose amicus briefs speak eloquently in support of our quest that there be formal and full recognition of the Joint Defense Agreement. There has been some issue presented in the briefs with respect to whether or not we are seeking to create a new privilege. We are not. This is a matter that is best termed the Joint Defense Doctrine or the Common Interest Doctrine. And in fact, the common law of Massachusetts has long recognized and fully vetted the issues of the attorney-client privilege and the work
Mr.
product
Cannon,
doctrine.
Let me ask you, though, as far as whether the information should be obtained, wouldn't it depend on whether the agreement was entered into in good faith for an independent reason? I mean, what if it's entered into just to thwart discovery? Then you could have cases where people could, any time two defendants were accused of a civil conspiracy, they could get together and essentially win the case easily by by making a joint defense, and then the plaintiff wouldn't be able to get the information that they needed.
That's theoretically possible. I would put that in the realm of the imaginary horrible, and it's certainly not extant under these circumstances. I know that Hanover
Why is it so imaginary? I mean, it may be this case, for all we know. I mean,
we have very extensive, and the record shows very extensive and numerous areas of commonality between and among the defendants.
Well,
this is not simply an issue where all parties wish to win. This is one in which we can enumerate each and every area of commonality and shared interest.
Mr. Cannon, if I could just follow up. Essentially what you have is Party A has a privileged communication, and the privilege is wholly intact against Party C. So Party C cannot get that information because it's privileged. Party B has privileged communications, and those communications are wholly intact against Party C. What is at issue here? So Party C couldn't get that privileged information in any circumstances. What you have here is if the privileged communications of Party A are shared with Party B because of commonality, does that break the privilege such that Party C can get access to them, correct?
Yes.
So we are only talking about privileged communications. In other words, if Party A and Party B engage in a conspiracy or develop facts, those in any event would not be protected because those are not privileged communications. In other words, a communication is only privileged if it is done for the purpose of seeking legal advice, correct?
Correct.
And the only thing that the Common Interest Doctrine or the Joint Defense Agreement deals with are privileged communications.
I agree.
Okay.
Can you tell me what other jurisdictions are doing about the Common Interest Doctrine?
Yes, the vast majority, as enunciated in the amicus briefs as well as our own briefs, do in fact recognize. I note that Hanover had cited the California case in the most recent Oxy almost at OxyContin, the Oxy case in California, is actually a broad recognition, and they're joining the majority of states. The cases are actually listed in both the amicus and in our own, the appellate's briefs, so that the vast majority of states do recognize it. There is some controversy as to how broad it is, and the Chief Justice actually focuses in on an issue as to when does the privileged communication or conduct begin? And certainly it begins following the agreement. It's very interesting in this case, and one of the grounds that I assert in support of our contention that there is a common interest here is that Hanover, as plaintiff, has alleged a conspiracy. I'm not suggesting that communications that took place back during the subject conduct would be subject to the defense, the joint defense doctrine.
Nor, by the way, if that conduct is conveyed to an attorney, does that make the conduct privileged? That is a profound misunderstanding of the privileged document. In other words, there may be facts. Take a fact. I agreed to sell my products at $10 a unit, and I do that in concert with a competitor, and we do that in order to dominate the market, right?
Yes.
I go to my attorney and say, I've agreed to sell at $10. That information doesn't become privileged because it is communicated to an attorney.
I agree with that.
Okay. So,
but my concern is that what is at issue here is post-litigation or actually post-claim communications between and among counsel. I recognize that if somebody robs a bank, simply by saying to their attorney, look, I robbed the bank, it doesn't become privileged information.
of course not.
Well, I understand that distinction. What we're here today
No, I understand.
concerned with is a series of, and actually there are two categories. There are communications between and among counsel and parties. And secondly, we're talking about bills. And the bills actually have two components. One, they are a direct communication from attorney to client. You know, dear client, this is your bill. But more importantly, or equally importantly, is the fact that the narrative to the bills are very extensive.
Does it matter here that if there was an agreement that it's oral as opposed to not in writing?
It does not.
Why not? I mean, couldn't people just make up whenever they feel like it? Say, oh, yeah, we had an agreement. We agreed to that.
Well, I guess the simple answer is they could, but we didn't. And I don't mean to be facetious, but there's corroboration of the existence of the agreement. There's obviously discussion. You'll note in the record appendix that there was a draft written agreement. So clearly there was discussion all the way back in 2001. And I cite to the affidavit of Roberta Fitzpatrick, which reflects activities in December of 2001. My own affidavit attests to the fact that in December of 2003 and January of 2004, I joined in it. So that I don't think that that's really the issue in this case. I think the conduct itself corroborates the agreement. And
but in any event, you know, there's no statute of frauds here, so you have an oral agreement, and an opposing party is permitted to test the existence of that agreement in exactly the same way that an opposing party can test the existence of a privilege. You can ask to whom the, you know, communications, I mean, all that kind of information, and presumably lawyers don't perjure themselves. I mean, if they do, they're in serious trouble. So that you can test whether there's an existence of an agreement, and essentially you've said, look at my affidavit and so on, I'll tell you that there's an agreement.
Certainly that's true, and I believe that Arbella has presented a privileged log. But what brings us here today is the fact that the motion judge miscited the law, suggesting there was no joint defense agreement. So
she said...
it has not yet been recognized.
Correct.
And then the implication of her further order was that an oral agreement is not sufficient in any event. And I would cite to what I think is a very erudite opinion by Judge Gantz in the Rhodes versus AIG case, and an equally erudite opinion by Judge McHugh in the American Auto Insurance case, in which both of them thoroughly analyze and discuss and articulate the common law of Massachusetts, which does recognize this and, in fact, does not require a written agreement and acknowledges the legitimacy and validity of an inferential or an implicit agreement.
Thank you.
I am out of time. Thank you very much.
Thank you, Mr. Cannon. Who we got here? Ms. Fitzpatrick.
May it please the Court, Roberta Fitzpatrick for the defendant, Appellant Arbella Mutual Insurance Company, and with me is Larry Schoen. First, to Justice Marshall's question, and so that we're all clear here, there is no attempt to use the joint defense privilege to protect otherwise underlying conduct or transactions.
I assume that.
This is strictly an attempt actually by an adverse party to get behind what is otherwise privileged information and is privileged by virtue of the fact of the attorney-client privilege, which is not in dispute. So that in, for example, this case, and ironically in the very case in 1871 which first talked about the joint defense privilege, the discussion is that when there are allegations against co-conspirators, it is of course natural and expected that those co-conspirators, years after the alleged underlying events and transactions, might seek advice of their own independent counsel, and that the attorney-client privilege that they each possess with respect to communications with their counsel is not and should not be waived because they share privileged communications with counsel who have a shared interest. And that's precisely why this whole issue is not the creation of a new privilege, but deals only with why there should be no waiver of the attorney-client privilege just because co-defendants with common interests share privileged communications and work product, which is protected, among co-defendants in a joint strategy. It has been suggested by Hanover that this is an attempt to do that, to protect otherwise unprotected or not privileged communications. We would say to this Court that if the Court were to do what Hanover suggests, what you open the Commonwealth up to and the judiciary system up to is fishing expeditions by adverse parties to claim waiver of attorney-client communications simply because they want to know what defense counsel are strategizing about. That completely undermines the entire system that we've developed, which would encourage candor between attorney and client, and the attorney-client communication would encourage candid advice between attorney and his client. And to the question of whether it's been recognized, judges such as Judge McHugh and Judge Gantz have made it very clear that it is recognized. It's alive and well in the Commonwealth.
Are there any appellate cases?
I was about to say, but as he says in the Rhodes case, there have been, although there have been no appellate courts that have yet ruled on the issue, this Court finds that Massachusetts law recognizes the existence of the joint defense privilege. And he quotes Judge McHugh, who found in 2000 in the Noonan case that in the final analysis, the privilege prevents waiver of the attorney-client privilege through disclosure between counsel or disclosures by counsel to counsel bound together in pursuit of a common legal enterprise. Now, what they say in both cases essentially is that when defendants have engaged separate counsel who work together in a common defense, information exchange between those counsel or between those clients and counsel is privileged to the extent that the exchange is part of an ongoing defense. So I think to Justice Cowan's point, there is certainly no effort here, and nor in the cases in which this privilege has been upheld across the United States, in every appellate case that has heard the issue, and in the federal courts as well, including the First Circuit in the Keds Foods case, which is in our appendix, that there isn't any attempt to protect non-privileged materials by the joint defense privilege. And if that were the case, that certainly would be improper. But here we are today suggesting that the Court affirm the existing privilege using really the contours defined by Judge McHugh and Judge Gantz, in which they say that the privilege not only applies and exists, but need not be reduced to writing and can actually be inferred from the nature of the relationship between the parties. And specifically, what the Court does in the Gantz case is say that there exists no talismanic method by which parties must prove that a common interest exists so as to eliminate the waiver, again, of otherwise protected information. Here, if we do what Hanover asks us to do, then, for example, the communication I had last week with my brother about our approach to defending this appeal and our approach to oral argument and the order in which we would make our oral argument would be subject to disclosure. Our work product would be shared, and shared work product is not protected it would be waived, unless, of course, there's a joint defense privilege. And here, the uncontroverted record establishes, by way of my affidavit, and nothing would be worth it to me to put my ticket on the line. I would not sign an affidavit, and I think most lawyers feel that way, if there wasn't, in fact, a joint defense agreement express, which occurred here. I would submit, as Judge McHugh found, you don't even need an express agreement. You certainly don't need a written agreement. You need only infer from the nature of the allegations that the conduct of the defense will benefit both defendants if it's done jointly, and if they candidly share communications knowing that they may not be exposed to an adverse third party. There is no reason, contrary to the assertions in the Hanover brief, for Hanover to get at my strategy relative to the defense of this case, nor my brother's strategy relative to the defense of this case, nor communications which our clients had with us and shared in order to develop our common defense, simply because they'd like to know. It doesn't make it discoverable. What they'd like to do is take advantage, frankly, of a waiver. And what the courts have done, and I would suggest properly, is to say there is no waiver in this context. It is an extension of a privilege which we all hold dear and which is required for the system to work. So I'd like to get to the contours of if this Court agrees with the reasoning in Judge McHugh's and Judge Gantz's decision as to the fact that Massachusetts recognizes it, albeit at the lower court level thus far, why this Court should, in fact, and I think we've already talked about it, but because there's no reason why we're looking at protecting information otherwise discoverable, and that's the first point. It's simply post-litigation, 4 years post-conspiracy, if a co-conspirator comes into my office, an alleged co-conspirator, and talks to me about what occurred, and I'd like to get on the phone with the lawyer for the co-defendant alleged co-conspirator and discuss the case, clearly those communications should not be waived in terms of the attorney-client privilege and should not be available to the adverse party. Now, the other arguments that were raised were that, and we already talked a little bit about that, it must be reduced to writing. And again, there's no support for that in any of the other courts, and there's no support for it here, although some cases have said there are written joint defense agreements and relied on them. They've said it's not necessary. And again, I would refer you to the McHugh and Gantz discussion on that. Finally, the issue was raised about the assent of the client. Again, there's no support for the requirement that a client assent to that. None of the cases that we reviewed, or nothing cited in Hanover's brief, provides any support for that notion. And then finally, on the commonality of interest, there was an issue raised by Judge Fahey in the lower court that suggested in the civil context there should be strict identity of interest versus common interest, as has been defined in both the civil and the criminal context. And on the, I see my time's just about up, but on the issue of commonality of interest, I would say to you that, again, Gantz and McHugh, Judge Gantz and Judge McHugh both discuss why taking that exception and making an exception essentially swallows the rule, because in multi-party complex litigation, there's rarely going to be complete identity of interest on every claim. We have 188 allegations in this case, numbered separately in the complaint. We have commonality on many of them. Perhaps we don't have commonality on all of them. Perhaps we do. It's irrelevant. The point is, if we have a common interest, as we've shown we do, and from the nature of the allegations, then the joint defense privilege applies to us simply because of the public policy of the Commonwealth. The very last thing
Ms. Fitzpatrick, thank you, but your time is up.
Thank you.
Mr. Gallagher?
Thank you. My name is Owen Gallagher, and I'm with Carol Azalea. We represent Hanover Insurance. Down below, our position was not that there's not a joint defense agreement. Our argument to the Superior Court judge was that these parties did not have a valid joint defense agreement. The context is very clear within the appendix. What we were looking for was a very finite list of documents. They were, in fact, a series of checks and an agreement that relates to an indemnity. This motion came about from a very simple fact. We learned that Arbella was paying the legal fees for Rapo and Jepson. That was quite surprising for this reason. The position of Arbella in this case is that it paid substantial amounts of money that was supposed to go to their agents that instead wound up with Rapo and Jepson. In other words, an antagonistic position. The money was not supposed to go to Rapo and Jepson. It was supposed to go to these agents, and it wound up with Rapo and Jepson. That's the defense. We say, no, we believe that you, in fact, had joined together with Rapo and Jepson to commit this conspiracy to transfer all this business over to us. When we found out that they were paying the legal bills, we said we'd like to get this. There were 8 9C conferences with Arbella when it was agreed that they would produce 6 checks showing they would have their legal bills. When they were supposed to produce them at the deposition, they instead said no. Rapo and Jepson claims that there's a privilege for this information. We then moved to motion to compel. We did not try to get any strategy, try to get anything.
May I interrupt you for a moment, just for clarification? So your theory was they were paying the legal bills, not that they were paying the agents, giving them the money to buy the books from the other agents.
Your Honor, there's 2 different things we're talking about here.
Okay.
In the record, there's a series of correspondence from Arbella to the law firm of Morris, Mahoney, and Miller. Each one of those letters states that for each agency, I have the one here which is on the record at 107, the Azar Insurance Agency, here's $430,000. When this sale goes through, give the money to Azar. When the sale went through, the money didn't go to Azar, it went to Rapo and Jepson. And Arbella's position in this case is it should have gone to Azar, but either 1, it was diverted by negligence by the law firm, or 2, it was diverted and converted by a person, Mr. Brennan, who was actually on the payroll of Arbella, but who they say was not authorized to make the transaction to say pay it to Rapo and Jepson.
Mr. Gallagher,
that's payment 1. I'm sorry.
I'm just looking at Judge Fahey's order. What she says is the privilege is not yet recognized.
Correct,
And
Your Honor.
you're saying that she's right on that?
I'm sorry?
She's correct on that?
No, Your Honor, we did not argue
No,
down...
but so you're saying, so she's wrong on that?
We're saying that there's no appellate court decision in Massachusetts.
Well, that doesn't mean to say it's not yet recognized.
There have been cases that recognizes it, Your
Yes,
Honor.
and it may well be that it is such a common practice that nobody would think to challenge it.
Certainly, Your
Right.
Honor,
So
we didn't...
she doesn't appear to be right on that. And then she says, especially in these circumstances where defendants have the burden of persuading that there's no joint defense. I think that goes, I can't read her writing, I think that goes to whether it's an oral or written.
Yes, Your Honor. I think the reference she's making here to Otis versus Arbella is another case that she decided that is in the appendix. I would point out that in Otis versus Arbella, this reference may be to the fact that there was a written joint defense agreement that Arbella had entered into in that case.
Mr. Gallagher, here's my question. If I have a privileged relationship with you, correct, but it turns out that somebody else is paying you the legal fees.
Correct.
What does that do? And I'm going to you. I am seeking legal advice. You are giving me legal advice. I am giving you information in connection with getting that legal advice, and you are giving me legal advice. But it turns out that my aunt is paying your legal fees because I can't afford you. What does that do to the privilege?
I don't think it necessarily does anything to the privilege.
Well, why does it make any difference if Arbella is paying? Now it turns out that my aunt and I, have had some disputes about this, the other, but she's still paying my bills.
The reason I don't think it makes any difference to the privilege is it's not privilege, the fact that the aunt is paying the legal fees. It's just not necessarily relevant to the case. That is, the privilege relates to communications, not to facts.
It's not entirely clear to me. Maybe the fact that she's paying, but how much she's paying?
Well, in this case, Your Honor, what we're saying is that the agreement to pay the legal fees was independent of the joint defense privilege. There's no question if there was no joint defense privilege claim here, the fact that Arbella enters into a post-claim indemnity agreement with a party could be relevant, especially where they take the position that the party is antagonistic or adverse to them. That has some probative value. Also, the amount that they're paying would have probative value. If they paid $5,000, it's probably irrelevant. If they paid $1 million...
May or may not. I think it's a very interesting area because, as you know, one can penetrate quite far into, who the attorney is and so on. But I certainly can't think of any case where it's clearly privileged information that the underlying documentation as to, the bills and so on.
Yeah.
We're not, may I point out, this order, we did not go seeking Rapo and Jepson's bills. This order is only against Arbella. We went to Arbella asking for the information relating to their payment of the indemnity agreement and the payment of the bills. It just happened that these very broad bills came to us, and we're not looking for them.
How many documents are you looking for?
There's 30 documents on the privilege list. On the privilege log, by the way...
Are they all payment of legal bills?
No, Your Honor. They're not.
Are they privileged? Are they are they privileged with respect to somebody?
We don't know, Your Honor. If you notice in the record, you will...
Let me tell you, there's a way to find out.
Well, in the record, Your Honor, there is no identification of the documents, and there's a letter from my sister...
But then the answer to that, Mr. Gallagher, is to press on facts, because you can... I see this all the time. There's a privilege log, and then counsel don't press. You don't get the documents, but you can ask for the date they were generated, who they went to, all those kinds of things.
Can't the judge look at these in camera?
No.
Certainly, the judge could have looked in camera.
Of course the judge can't look at them in camera because they're privileged.
I'm sorry, Your Honor?
The judge can't look at them in camera because they're privileged. If there has been a real attempt to get all the information and the judge still can't decide, the judge should be able to decide on the face.
Well, here's a letter at the record at 115 from my sister. We had pressed about getting at least the details as to what the documents were. They have the date and they have the parties. That's it. There's no further description, and we pressed. And it says, I am unable to provide any specific detail regarding the specific communication without waiving the privilege.
Well,
at that point, we went to court.
Yeah, but the answer to that is I don't know what she means by details, and I'm not making a ruling on that because that's not what I'm asked to rule on. But one thing you do is you say you don't provide detail of the communication, but you can say, I want to know who generated the document and to whom they went. That's a classic inquiry to find out if a document is privileged.
But your answer is she's going to come back and say, I can't tell you that.
Correct. Well, no, we do know who they went to. The privilege log is here, and it has who they went to. It doesn't.
Why a judge can't look at these things. I mean, judges look at privileged material all the time. We do it in this,
Are you claiming that they are not privileged based on who they went to?
No, Your Honor. What we were saying was that insofar as they have claimed the joint defense privilege, we had argued down below that because of the nature of what they're claiming, that they had not established a joint defense privilege.
Were these communications that went to counsel?
Yes, Your Honor. For example, 3 of the communications on the privilege log relate to joint defense privilege involving Mr. Brennan. The affidavit from my sister says...
Who is Mr. Brennan?
He's another defendant in this case, Your Honor. He did not file a brief.
Okay.
Well, he's not a lawyer, is he? Or is he?
I'm sorry. He went to Mr. Brennan's lawyer.
Oh.
I'm sorry. Mr. Brennan, his counsel. The affidavit states that he entered into the joint defense agreement on January 2004. The documents that are listed here under the joint defense privilege that went to his counsel are all in 2003.
But that doesn't make any difference for the joint defense privilege. It makes no difference at all. The question is, was there a joint defense agreement at the time that one member of the joint defense provided the information to the other?
Well, the affidavit from my sister is that he didn't enter into a joint defense agreement until afterwards.
Until after he entered in the joint defense agreement before his lawyer received the documents.
No, that's what
this
is in 2003, Your
No, not
Honor.
when the document was created. When did it go to Mr. Brennan's lawyer?
2003. And the affidavit is that he entered into the joint defense agreement, the lawyer entered into the joint defense agreement in 2004.
From what I'm hearing
it's
here,
here as
it
being
seems to
privileged.
me that the issue isn't about the joint defense agreement. The issue is whether the underlying documents are privileged, period.
Correct.
That's really what the question is. And we got all bollocked up maybe because of what the
I couldn't
judge
agree
below
with you.
did. But the underlying issue is very simple. Are these documents privileged?
The major documents we're looking for relate to the defense
Mr.
agreement.
Gallagher, I have a judge's order that says, I'm ordering you to produce them because There's no joint defense agreement, and in any event, to the extent there is, I don't think one has been established here.
Correct.
She's wrong, perhaps.
She may be wrong on the fact that there is no joint defense
In which case, we reverse her order.
Pardon?
We reverse her order.
Well, you can also affirm it insofar as...
No, because I don't know. I'm not going to sit here making privilege determination. She hasn't issued an order that says this document is no longer privileged because it was given to a third party before there was a joint defense agreement, therefore the privilege is waived. She makes that determination. We review that question.
So we say, Mr. Gallagher, she's wrong. There is a joint defense agreement. Let's assume that. Appears fairly well established. And then we're down to a fight between are these things privileged or are they not privileged?
Correct.
That's the essence of your case.
Correct, Your Honor.
Now, I still can't see why a judge can't look at them on camera and decide whether they're privileged or not privileged. How the hell else are you going to decide it?
Your Honor, I didn't file this appeal. The order came in, we looked for this, it was filed...
Maybe there's no law to this effect, and I certainly would be predisposed to create it. Assuming the rest of your case is valid.
The judge doesn't look at something in camera if one side says it's privileged and the other side says it isn't. We require parties to go through very carefully and to ask for very specific information which is well set out in the treatises that says this information is not privileged. I do not think that includes how much money you paid your lawyer or the content of the bills. But you can, for example, ask, was this memorandum distributed to, well, tell me to whom it was distributed. Oh, it turns out it was distributed to Mr. Brennan, and he wasn't part of the joint defense agreement. Theoretically, the judge doesn't have to look at that. You may say, on its face, that means it's not a joint defense, it's not privileged, because the privilege was broken. It may be privileged at the time the privilege was broken. That's what you do.
Correct, Your Honor. No, our position, as I said, is we did not contest that there could be a joint defense agreement in Massachusetts or that there was. It was on the factual basis.
I didn't think you would, Mr. Gallagher.
No, it was on the factual basis as to whether they had a joint defense agreement, and the judge down below, except for the fact she stated there was no joint defense agreement, her finding was that they have not established that there was, in fact, a joint defense agreement. Because there was an unsigned agreement, and there was no affidavit from the lawyer who supposedly entered into the agreement with my sister. And there's always the possibility that one person thinks there's a joint defense agreement, you sit down and you say, okay, let's put it in writing, and it doesn't happen. And that is, the evidence is, what did the lawyer that was at that time representing Rapo and Jepson understand? That was never put into evidence. All you have is an unsigned joint defense agreement, which we believe was not sufficient to establish that you, in fact, had one.
And as I say, I think you don't have to have a signed one, but you may be right.
Well, but there's a different question in which you're saying if you try to put, you think you have an agreement, and you try to put it in writing, and you can't put it in writing, obviously you don't have a meeting of the minds, and you don't default back to saying, each party saying, well, okay, we don't really agree on anything, but we still have a joint defense agreement, so we can keep the information from that third party.
But do we even have to get into that? If all you're asking for is non-privileged documents, and they say it's privileged, we can just skip over this other stuff.
Correct, Your Honor. And that's what we tried to do down below. We did not get into the... That was their defense, that it was privileged.
No, I know. Okay.
And our opinion is that the judge's order should be affirmed insofar as it finds that there was no joint defense agreement. Thank you.
All right.